All right, good morning. My name is Don Parsons. I'm a Vice Chancellor on the Delaware Court of Chancery. For those of you who might not be that familiar with the Court of Chancery, it has 5 judges. There's a Chancellor and 4 Vice Chancellors. I know Vice Chancellor Strine teaches here, and he's down the hall from me in our chambers in Wilmington, Delaware. So it's a real privilege and a pleasure for me to be here as part of your program today on hedge funds. I owe that to Blaine Statham, one of my externs last year, who was kind enough to invite me to participate. And Blaine has been working on an article relating to the hedge funds, and I've certainly benefited from reading drafts of that and so on. Today, our program this morning is on regulatory measures and alternatives to regulation. I'll just briefly review the panel agenda. First, we're going to hear from Professor Booth. His title, A Hedge Fund is Your Friend, Executive Compensation, Corporate Governance, and the Problem of Overvalued Equity. So we're sort of going to be looking at some of the internal things related to hedge funds. After that, we're going to have Troy Paredes from the SEC on SEC regulation of hedge funds. As most of you know, there are many aspects in which hedge funds, although they generally are not under the regulations of the SEC, it's still critical that they abide by all the laws to make sure that they come within the various safe harbors and exemptions that exist under our federal securities laws. Then we'll hear from Professor Skio on hedge funds and bankruptcy, and then lastly from Doug Cumming on international experience with hedge fund regulation. Just very briefly, and my few remarks are more in the nature of almost an overture, just a little bit. What are hedge funds? They're notoriously difficult. It says to precisely define. I would just say to define, period. If you go up to anyone and ask them what's a hedge fund, and a lot of times I've asked this question to people who seem like they ought to be knowledgeable in this area. Many of them teach in the area and so on. The definitions are so mushy that you just say, show me someone who knows what they're talking about. The problem is that it is a very difficult thing to define, and so you have to look at some of the characteristics. They are not venture capital funds or private equity funds. They've got a different investment style, a different governance structure. If you had a venture capital fund, it might be somebody like, there's a Five Below, if you've ever seen those stores like Five Below or some sort of thing like that. And that it started up a few years ago, and someone might go in and say, well, let's get a group of investors together. We'll all invest in Five Below. But when you put your money into this private pooling of funds, everybody understands that you're not getting your money out anytime soon. You can't call up and say, oh, I want my money back, because the idea is you put your money in there, and somewhere in a 5 to 10 year horizon, the company will sell or it'll go public, or in a different way with new securities offerings. Some big event will happen. That's when you get your money out. But you're sort of in there a little bit for the long, short term. It's not that far a time horizon, but it's not like a mutual fund where you get it one day and 3 months later you need cash or whatever, and you say, sell my shares in the Fidelity fund that I have or something. Private equity funds are not quite that nature. It's like hands-on investing in companies, that they like the management of a company. They usually work with the management of a company. They'll have somebody on the board that's watching and asking the hard questions. It's a very active management in that company. Hedge funds, they're not a separate class like stocks or bonds, and some of the salient characteristics, which we'll go through a little more, is that they generally aren't registered. I'm going to go through here very quickly and just mention a couple of highlights, because I'd like to speak just a few minutes about hedge funds and the Court of Chancery. In terms of performance, one thing that is different about hedge funds is there'll be a fee, just like you pay when you're in a mutual fund. There's some sort of a management fee, 1-2%, might even be as high as 8.5%, I believe. But you'll have that in a hedge fund, but you'll also have a performance fee. And it can be as high as 20% of the performance that's achieved. And that some of this goes back, it's almost 60 years ago, in 1949 was one of the early, some people say the first, hedge fund was an Alfred Winslow Jones. He was a sociologist, and through various exposures that he had, he became interested in investing, but he wanted to be able to invest in securities and also sleep at night. So he started coming up with these hedging strategies, short and long at the same time, things of that nature. And he was one of the very first, or one of the pioneers in the in this hedge fund area. So it's really just in the last 60 or so years that we've got much of a history with respect to hedge funds. They also are, this is down toward the bottom here, that they do use leverage many times. Not all hedge funds use extensive leverage. Not all hedge funds use short and long strategies and that thing. It's a very diverse type of investment way, or many ways that they can proceed, but that's one that's typical. And then they usually are limited partnership or LLC type arrangements, not corporation or that sort of thing, usually a limited partnership. If I go on to the next slide, whoops. You can see from January of 2000, there were something less than 3,000 hedge funds, and they had about $323 billion under investment. If you go from then up to January of 2007, so that's a year ago, by that time we were getting up above 14,000, so almost a five-fold increase in the number of funds in the last 7 or 8 years, and also the number of the assets. We're going from 3 up to 16, so it's 5 or 6 times. So that hedge funds, there's been a steady increase in the number with respect to the hedge funds. I'm going to skip over. Well, I'll just mention briefly, I'm sure others will mention it today. In the late 1990s, there was long-term capital management, and that had Nobel Prize winners and so on. It had a very highly respected group of managers. They came in, they had this investment strategy. It was hugely leveraged. That they had I think the number we have is $4.8 billion was their capital base, but they had been loaned money and investing money up at the tune of $125 billion. Then the Russian debt moratorium came into place. It sparked a flight to quality, and the risks were spread all over the place. People began reacting in such a way that all the risk that they were exposed to in the long-term capital management came to roost. It ended up having to be bailed out through assistance from the Federal Reserve Bank of New York. So there started to be an emphasis on better risk management, improved disclosure to the investors, and that continues to the present time. We will have discussions about outside the existing regulatory framework. I won't go into these details. We do have Troy Paredes who will be speaking about SEC regulation. There are 4 acts to worry about: the Investment Company Act of 1940, the Investment Advisors Act of 1940, the Securities Act of 1933, and the Exchange Act of 1934. Since I'm in a law school, you know how you can glaze over as you read all these provisions and try to match them all together. Fortunately, we have an experienced practitioner in that area, and we'll get some additional guidance on it today. There are issues regarding accredited investor that are very hot topics today with the SEC, and there's a lot of policy discussion relating to that, so maybe we'll hear more about that. Let me just talk to you very briefly in the last couple minutes before we turn to our speakers about how the Court of Chancery interacts with hedge funds. We have hedge funds before us in many different situations. We have mergers and acquisitions and other types of corporate restructurings in which hedge funds may be involved. But we don't really view them any differently than any other kind of acquiring company or partnership or corporation. So there's nothing that new in that regard. Although one thing that I've noticed with respect to hedge funds, and especially situations where you have short sales, extensive short sales, you may have somebody who's got 1,000 shares long in one account and 1,000 shares short, or 1,001 short in some other account, and they're hedging the way the long and short runs. Holding shares long, it's just that you own the shares, period. That's called holding them long. You really own the shares. Holding them short, you've borrowed the shares from somebody, and then you've sold them to somebody else, and you hope that 3 months later, or whatever the time period is, when you have to give the shares back to the person you borrowed them from, the price will have gone down of those shares, and you can buy them back in the marketplace for less than you sold them for. So you sold them for $100 a share. 3 months later, they're worth $80. You have to give back the 1,000 shares you borrowed. So you pay $80, give that back, and you pocket the $20 profit. Now, there is when you borrow your shares, there's a cost that's associated. The brokerage house that's lending you the shares is charging you some, it may be some small percentage, but you will make a healthy profit if the share value goes down. So you have the situation with people who are short sellers, that they do better when your stock does worse. So when I have people appear before me and it's a hedge fund on the other side, I'm the company and I'm trying to manage for the long term and protect my directors and protect my shareholders, and here's this disgusting hedge fund is over here buying these shares, praying that our stock's going to go in the toilet and we'll be able to, make some huge profit. So there's it's a very pejorative kind of description that they're giving to what's happening with the hedge funds. We don't pay any attention to that. There's all kinds of different ways that you can invest, and as far as we're concerned, the hedge fund is as legitimate as any other way, the short selling, and we just try to focus on the merits. But some of the problems that arise is when you have a corporate vote and there are extensive short sales, you can have a situation where it is not one share, one vote. And this affects Delaware corporations in a way so that, we all assume that if you have one share, you can vote that share yes or no on a proposition. But if it's a loaned share, and it might be Merrill Lynch or somebody loans the share to a hedge fund, but then a proxy comes out. Well, Merrill Lynch sends that proxy to the person who really owns the share, to their, one of their investors has these shares, and that person theoretically can vote that proxy on the shares that it has. Merrill Lynch doesn't have it at the moment. It lent it out to somebody else. The hedge fund, in turn, has sold it to another, and that person is the owner of that may be the real beneficial owner of those shares. They also get the proxy, and you end up having two people voting the same share, and it may even get worse than that. So it's Henry Hu is going to be speaking by video conference this afternoon, and he'll talk to you about some of those things. You hear talk of empty voting, things like that. It gets very complicated as a result of all these derivatives and mechanisms that separate the vote from the ownership in the share. Another thing, those of you who have had corporations, you may have heard of Section 220 actions. A 220 action is where a shareholder thinks that something's going wrong in the corporation, that they're making bad decisions, that maybe there's some breach of fiduciary duty that's going on, and they are a shareholder, and they are entitled under the Delaware Corporation Law to put in a request to give me all the books and records relating to a particular decision that the corporation made. And they can look at those records, and our Supreme Court and the Court of Chancery encourages plaintiffs to do that. Go get the books and records, look at all the emails, look at all those things, and figure out if it really looks like you've got a claim. And if it does, well, then you can put the facts into a complaint and file for breach of fiduciary duty or whatever else you do. In a case that I had, Deep Haven Risk Arbitration Trading versus United Global Com, there I had, Deep Haven was a hedge fund. And the hedge fund had 5 different accounts, 5 different, like one would be with Merrill Lynch and another would be with another huge investment banking kind of or brokerage house, and they had 5 of these. In one of the 5 accounts, they always were long. They always owned the shares. In the other accounts, they were short and long and all over the place, and their net position, when you added up what they had in all 5 accounts, was short. So they were net short. And the company's lawyer is coming in and he's saying to me, Your Honor, don't give these guys our inside, don't let them look at our internal documents. They're looking for dirt. They want to put it in the marketplace and drive down our stock price. That's the way they make their money. So it's, you know, they don't have an interest that's the same as the stockholders. And you'll see that one of the requirements that we have is that you must have a proper purpose for a request for documents. That means it's reasonably related to the person's interest as a stockholder. In this particular case, I did allow them to get the documents they asked for, but only because I found they had a proper purpose. The particular purpose in that case was that the company had put out a rights plan, and it gave the option to all stockholders that they could, if they opted into this program, they would have an opportunity in certain circumstances to buy stock at a 40% discount. The hedge fund figured that not all 20 million shareholders will take up the option. And if it is undersubscribed, there might be 1 million or 2 million shares who don't, you know, foolishly maybe, but they never opened their mail or they couldn't make heads or tails of it and they just never sent it in. That would present an opportunity for the hedge fund to get additional, not only to take all the shares they had, but they'd be able to get additional benefit. The company came out and said about when the first round was over, there were 100 million shares altogether that we were talking about. 19 million had not been exercised. It looked like it was going to be a huge windfall for the hedge fund. 2 weeks later, the company said, oh, I'm sorry, we made a mistake. There's only 100,000 shares. All of them, I'm sorry about that 19 million, it's only 100,000. And all of a sudden, this huge profit the hedge fund expected disappeared. In that instance, it seemed to me that it was a legitimate interest of the hedge fund. They weren't trying, their interest was not necessarily adverse to the shareholders. Everybody wanted the rights plan to work the way in which it had. All right, it's been my pleasure to be able to talk to you a little bit about this. I'll just mention one last area that I do have cases now that involve actually shareholders in a hedge fund trying to get out of the hedge fund. It's very much unlike a mutual fund. You call up and you say, I want to get out. In this instance, there are 2 days. You have to tell the hedge fund a month before June 30th or a month before December 31st of each year that you want to get out. If you don't, then you're in for the next 6 months. And then once you tell them that you want to get out, they can't just turn around and give you your money back or give you the shares, because this money is invested in derivatives and things like that. It may not be all that liquid. And so they need some time to go get the money, to go change whatever their investment is into money or whatever they're going to give you. So they have a 30-day window to do that. And that's all defined in the LP, the limited partnership, or the LLC agreement, all these kinds of rules and regulations. It's a private contract. What happened in this case is you had a right to get you want to get out. You can either get your investment in kind, which means they'll take some of the shares or derivatives that they actually own and they'll give them to you. Or else you could get cash. And sometimes people, the investors, want it in kind so they don't incur a taxable event or things of that nature. So what ends up happening is they say, okay, we want it in kind. And the company says, all right, well, we pick these assets. It's 10% of our assets. And that's what we're going to give you. And I know you had $100 million in our hedge fund. 30 days later, we have to give it to you. And unfortunately, you know, the market, things didn't go well. It's only worth $60 million now, but here it is. And they give them the stock. And the fellow who was in the hedge fund, he said, well, wait a minute. I had $100 million then. You have to give me $100 million worth of assets. You can't give me. So there's this question of who bears the market risk during this month, and that depends on construing the contract. So there are a number of issues, contract, corporate governance, internal type affairs that do end up in the Court of Chancery that relate to how these operate. All right, I'm going to turn the program over now to our first presenter, and that's Richard Booth. He's the McGuinn Professor of Business Law at Villanova University School of Law, a graduate of Michigan and Yale Law School. And prior to joining Villanova in 2007, so just recently, Professor Booth was the Marbury Research Professor of Law at the University of Maryland School of Law. And before that, he was members of the faculties at Case Western Reserve and SMU. He practiced law in New York with the Donovan Leisure firm in the areas of corporate and securities litigation. And he has published very extensively in the area of corporate law, such things as being the author of Financing the Corporation and another book, Appraisal and Valuation in Corporate Law, Corporation Law, and then he's also been a co-author on Business Basics for Law Students, Fundamentals of Modern Business, Attorney's Guide to Business and Finance Fundamentals, and so on. So he's certainly an expert in this field. We're very fortunate to have him, and today he's going to talk to us about why a hedge fund is your friend. Thank you.
Do you want your watch back? Or do I get to keep it? That might be useful. Thanks for the introduction. I'm impressed with myself. Anyway, I'm not sure that my that my topic is really the best one to get this thing kicked off. I'm really quite skeptical of the need for pretty much any hedge fund regulation, but I have some positive arguments about why that's the case. So I guess in one sense maybe I can sort of be the foil here and everybody can take pot shots at me for the rest of the morning or maybe even the afternoon. Most commentators seem to be worried about hedge funds, I guess from two different points of view. One is that one worry is that maybe they're taking advantage of investors and that investors need protection from hedge funds. I rather doubt that because it's the investors that they seek are relatively sophisticated, and I suspect that they have relatively little interest in smaller investors because that would increase the number of investors and increase the chances of regulation, even under current regulations. I mean, you've got to keep these funds small in order to keep them private. So I don't really see a lot of danger there. Perhaps the bigger worry is that hedge funds have become too powerful, and I'm sure we're going to hear a lot about that. Too powerful and too secretive. I'm sure we'll hear a lot about that the rest of today, but in a sense my argument is that the fact that they are powerful is an important thing to keep track of, and what they do with their power can be a very positive force for corporate governance. There are a few commentators out there who have argued that hedge funds could indeed be an important force in corporate governance, rather like it was hoped that institutional investors might be back in the 80s and early 90s. I think most people figure that, or have come to the conclusion that institutional investors, mutual funds, pension plans, and so forth, have done less than they might. I'm not sure that I agree with that. I think that they have induced an actual shift in corporate governance, largely as a result of inducing compensation based on equity. And I won't get into the story about how that worked exactly. That's another article and another presentation. So I think institutional investors have had an impact, but I think that it's not likely that that they can do much more than they have already done. And I think that hedge funds, therefore, may be a more important source of discipline in the years to come. And I think that they need relative freedom and freedom from regulation in order to do what they might be capable of doing. Well, anyway, let me get to my more precise thesis, and it is that the efficiency paradox has come home to roost. I mean, we're in the middle of an election season here, so a story by analogy, I think, might give you some sense of what the efficiency paradox is. An economist walks into a bar on election day, and the bartender, of course, says, well, who did you vote for? And the economist says, well, I didn't vote. My vote's not going to count. I'm only one of 150 million people are going to cast a vote. It's not going to make any difference. I'm assuming this bar is not in Florida. But the bartender says, well, that's terrible. That's totally unpatriotic. It's un-American. What if everybody behaved that way? And the economist says, well, then I'd vote. So we've got a bit of the same thing going on, I think, in the stock market. When I say the efficiency paradox has come home to roost, I think that people have become convinced of the efficient market hypothesis, are largely convinced of the efficient market hypothesis, and of the benefits of broad diversification. Those two very powerful theories sort of lead inexorably to the conclusion that it doesn't make a lot of sense to pick stocks. That is, one should simply be a price taker with respect to investing in stocks. Invest in a well-balanced and broadly diversified portfolio, and you will do as well as the market does. You can't beat the market anyway with publicly available information, so at least not on balance. You'll beat it about as often as you would expect to as a matter of pure chance. So why not just be a price taker and save the money that you would otherwise spend on doing research and engaging in excessive trading, and your investors, if you're an institutional investor, your shareholders will be that much better off because you've spent less money. I mean, some people have taken this to the extreme, of course. Index funds, which account for about 7%. I'm surprised it's not higher, frankly, but index funds quite openly eschew doing any kind of research other than what it takes to figure out what constitutes a balanced portfolio. So there's no effort made on the part of many funds, and therefore on the part of many investors, to try to find stocks that are misvalued in the market, whether they're overvalued or undervalued. Just doesn't matter. You invest in a diversified portfolio. That means that there's a dark side to that, and the dark side to that is that it's like the economist who would vote if nobody else did. If the market starts, or if most investors believe in market efficiency, Now there are opportunities for some investors who do the research, perhaps to find the stocks that aren't properly valued in the market. Where that equilibrium ends up, that is, how many investors are likely to engage in that sort of behavior, is a little bit difficult to predict, but there's been some research on the question. I think there's a lot of research that still needs to be done, but the estimate is that maybe about a quarter of all trading in the market, 24% actually, is motivated by stock picking behavior. Now you have to be a little bit, well, I'll talk about this in a second, you have to be a little bit careful about some of the statistics in this area, because sometimes the numbers really should be compared to twice total value of the market as opposed to, so 24% doesn't necessarily mean really 24% if you recognize the fact that there's always somebody on the other side of a trade. In any event, assuming that that number is correct and that it accounts for that it's a correct measure of how much stock picking behavior is going on. It's interesting that it's also been estimated that hedge funds account for about 50% of the trading that goes on. Now, I think that number is a twice total value number, and the 24% number is an adjusted number based on total volume. Consequently, that would suggest that hedge funds are responsible for virtually all of the stock picking that goes on in the market. Now, I can't vouch for these numbers, but because I didn't do the research myself. But if that's the case, it would seem that hedge funds are probably the single most important source of market efficiency. That is, that doesn't appear that there are very many other people out there who are driving stock prices to where they ought to be. I'm sure I'll get some comments about that. So anyway, why is this so important? Why are we so all-fired concerned about market efficiency? I mean, there are some commentators who've actually suggested that it's not a terribly important thing to be worried about. That's where I get into the connection to executive compensation, which may seem like a strange connection. But it's something that I think is particularly important in the aftermath of the recent scandals, Enron, WorldCom, and so forth. Michael Jensen and Kevin Murphy have persuasively argued that many of the scandals were caused by that famous irrational exuberance that Alan Greenspan talked about. That is, they were ultimately caused by the fact that equity was overvalued in the market. Now, how could that cause the scandal? Well, it's connected to the fact that equity compensation had become pretty much the norm. In fact, as of the late 1990s, right around 2000, something on the order of 90% of all CEO compensation came in the form of equity, mostly in the form of options. In the meantime, I think it's flipped to a little bit less options and a little bit more restricted stock. Nevertheless, clearly the vast majority of executive compensation, or certainly of CEO compensation, comes from equity. Well, the problem that Jensen and Murphy point out is that if the stock price of your company is higher than it ought to be, options and equity are going to induce you to do risky things to keep that stock price as high as it possibly can be. Not necessarily as high as it possibly can be, but to keep it from falling. No CEO And I'm not sure that compensation makes that much difference in this connection, but no CEO wants to preside over the devaluation of her company, to go into the boardroom and say, hey, guess what? Our stock is trading for twice what it ought to. I want to take some steps to make the stock price lower and more consistent with the business that we are really going to be capable of doing going forward. I mean, there's some wonderful anecdotal evidence that they come up with. The CEO, for example, of eToys, that one of the famous high flyers and then big failures of the .com era. The day they went public, the stock ended up trading for twice what the CEO thought could be sustained going forward. It induced the company to invest in additional warehouses, transportation, all the kinds of stuff that e-businesses have to invest in order to somehow provide for the kind of volume that was going to be necessary to justify that stock price. Well, guess what? There wasn't that much business to be done in the toy industry. And as a result of overinvestment in an effort to keep the stock, in order to justify a stock price that was already too high, the business overinvested and eventually went bust. So here's the question. How do we... I mean, options are great as far as executives are concerned for getting the stock price higher and keeping the executive focused on making sure that the price goes higher. But what happens when the price gets too high? I mean, options can't induce you to lower the stock price because you'd be shooting yourself in the foot. Well, there are a couple of things that could be done, all of which I think are probably unrealistic, politically speaking. I mean, one thing we could do is we could index the price of options downward, so that as the price of in the market goes down, so as market prices generally go down, option exercise prices go down. Well, that's like automatic repricing, and repricing is one of the things that people just seem to think is just not playing fair. That is, it's heads I win, tails you lose sort of behavior on the part of executives, and it just doesn't seem like that's the way options should work. But, you know, if the problem is that sometimes the stock price gets too high, maybe it should. Here's another good idea. What about if we permit CEOs to engage in insider trading when the stock price gets too high? That would be a good, I mean, you can make money on the downswing that way. I think there are probably some people have actually suggested that, and I think there are probably some problems with that, with that solution. So what we're left with by process of elimination is, in terms of trying to make the market more efficient on the downside, is somehow, I wouldn't say encouraging people to bet against the market, namely hedge funds. I don't think we ought to encourage people to bet one way or another when it comes to stock prices. But I think that at the very least we should be careful not to discourage people from betting on the downside of the market. Now, there have been several positive moves recently that have kind of opened up the possibility of betting against the market. One is most recently, actually, the abolition of the SEC's tick test. That is the test that essentially made short selling illegal in a market that's already going down. The idea of the tick test was to avoid a so-called bear raid, which was a worry that was left over from the 20s, frankly, and probably not a genuine worry anymore. The tick test, the SEC claims to have been opposed to its own tick test for many, many years, but it took them a while to get rid of it. Now it's gone. And in addition to that, the SEC has indicated, although it hasn't actually done this yet, it's indicated that it might approve actively managed exchange-traded funds. That might might assist a little bit with helping to keep the market efficient. Probably the more important developments have been the advent of single stock futures. There's a peculiar thing about futures. I mean, if you listen to the business news, you've probably heard some references to the fact that the commodities market is booming. Commodities prices are going up. Everybody's doing great. So people seem to have lost track of the fact that in the commodities market, there's always somebody betting. It's always a two-way bet. I mean, whenever a commodity goes up, whoever's making money is making it at dollar for dollar at the expense of somebody who's losing money. So it's a strange thing to talk about futures markets and prices going up. It's just not what futures markets are about. But my point is that single stock futures are completely balanced in terms of somebody takes a bet in favor of a rising price, somebody has to take a bet in favor of a falling price. Options essentially work the same way, and the options market is vastly larger than the single stock futures market. In fact, the options market, as far as I can tell, accounts for about a third. I mean, if you were to take all of the trading that goes on the New York Stock Exchange and then compare that to the trading in options, both puts and calls, and the number of shares covered, the total volume of option trading is about 35% compared to the New York Stock Exchange, which would be 100%. So options trading has been booming in the last few years. It's been increasing on the order of 25 to 30% per year in terms of the number of shares that are actually covered. And options, like futures, there's always somebody on both sides of the bet. Somebody is betting against the price going up, or somebody is betting against the price going down each time somebody buys or sells, or buys a call or buys a put. So you've got that perfectly balanced kind of thing going on. So I find those to be positive developments that can assist in keeping the market more efficient than it might otherwise be. But I think hedge funds, again, to get back to the basic statistic here, if it's the fact that hedge funds account for about, well, the number is, the estimate is 40 to 50% of trading. And if it's the fact that only about 24% of trading is based on stock picking behavior, as opposed to the other kinds of things that might motivate trading. Program trading, portfolio balancing, tax planning. There are lots of things that might motivate trading. So it's not unbelievable that 24% might be about the amount that is motivated by stock picking behavior. It looks like hedge funds are a very important force in getting stock to the price where it ought to be. Well, I think I probably ought to wrap this up. I think I've made my point, but we've had some references already here to some Nobel laureates, the ones that were behind the long-term capital management thing. One of my favorite Nobel laureate stories involves James Buchanan, who won the Nobel Prize in Economics years ago. I don't know what year he won it. But on the occasion of being awarded the prize, it was probably also an election year, he was asked what his advice would be for the president with respect to, how to handle the economy during the coming term. And his answer was, don't just do something, sit there. So that's that's what I think that's good advice for hedge fund regulation. I'll leave it at that.
Well, hold on. Why don't we?
Okay.
We'll keep you there for a moment in case there are some questions or anything from the audience.
I have a question.
Yes, go ahead.
Richard, you talked about the Jensen-Murphy view of the problems with equity compensation running up to the corporate scandals. Are you at all worried about the exact same phenomenon occurring with hedge funds themselves, since their compensation scheme is quite similar to the kinds of compensation that created problems in the 1990s?
No, I actually think that one of the dangers is, I think that the way hedge fund compensation is really quite comparable to the compensation that you get in connection with venture capital funds and with private equity funds and with REITs for that matter. It seems to be quite standard across all of these relatively unregulated kinds of investment vehicles. So there's kind of a safety in numbers in that sense. I don't think that investors would tolerate things like 20% carried interest, and that the tax folks are going to have some things to say about this, I think, in the coming session. But I don't think investors would tolerate that if they didn't think they were getting value for it. And I think, quite frankly, that it's one of the strengths of the hedge fund industry that there is as much incentive as there is to deliver returns. And the fact of the matter is that the returns that the hedge fund industry has delivered apparently aren't all that wonderful. They're on the order of 8 to 9 to 10%. Some, obviously, many do better, and many do worse. But so I suspect that the 20% doesn't often kick in. Maybe occasionally it does. But bottom line is, no, I'm not worried about it. Okay, over there, I guess.
One question, I guess, in terms of, or one view that I've heard about hedge fund compensation is that it's actually leading towards less risk-taking in recent years than more risk-taking, because the asset-based fee, as these funds have grown so large, without doing anything, without having returns, these hedge fund managers are making extraordinary amounts of money. Beyond the executive comp of the public companies you were talking, leading them to take less chances, because if they could keep most of their money tracking the indexes and take a little bit of a gamble with some, as long as they outperform by a little bit, which may be leading to some of these 8 to 9% results, people don't redeem. They keep this huge asset base and they make a lot of money. And some clients that I've had in fund-to-funds are saying I end up investing in index funds lately because these hedge funds have become less risky. So I think it's along the lines of what you're saying, is there's always two sides to these things, and there should be encouragement to some degree to allow these funds to be creative, take risks, and hopefully arb out and hedge out the efficiencies in the market.
Yeah, I think what you're saying is, I think if hedge funds fail to deliver, then people are just going to go back to regular old mutual funds or other sorts of conventional vehicles. Actually, one thing that I didn't quite get to say that I'd like to add in is that I think that we should be careful not to overregulate hedge funds and sort of prevent them from doing the valuable things that they can do. But I do think that there are a couple of areas in which there's some danger that we might be being a little bit too solicitous of their needs. For instance, I suspect if hedge funds in fact are doing most of the stock picking in the world, I would think that they would be probably in favor of our system of securities fraud class actions that we currently have, which I think is absolutely broken and should be trashed. In a way, they would seem to be the primary beneficiaries of the securities fraud class action system that we have, and in effect, I think what's happening is that we're subsidizing hedge funds by letting them recover when they happen to discover that there's been a fraud in connection with, I use the word fraud loosely, a fraud in connection with one of the stocks that they happen to have bought, or for that matter sold, but it's almost always a buy. So I think that there's a subtle subsidy running to hedge funds that we probably ought to get rid of. I'm very anti-subsidy. And just to sort of give a little pat on the back to the Chancery Court, one thing that, one of my favorite cases, it goes back a ways because it was an Allen case, but the Marriott case involved when Marriott did a split-off or a spin-off of its real estate business as opposed to its hotel management business. There were 4 hedge funds, investors actually, Harvard was one of them, who had engaged in a very complicated strategy of essentially shorting the Marriott preferred stock, not shorting the stock, but buying the stock and selling the common because it was convertible preferred stock. And the 4 investors who had bought virtually all of these preferred shares came into court and, as a result of some maneuvers on the part of Marriott, said, you know, it's terrible what they've done here. They've completely eliminated our return on our investment because they've canceled the dividends, or they've said they're not going to pay dividends on the preferred stock. And after a lengthy and really quite complex opinion, Allen essentially threw them out of court, saying, I mean, one thing that he was saying implicitly is, you know, you made your bed, so sleep in it. We're not going to sort of interpret what this preferred stock contract means on the basis of peculiar kinds of strategies that you have adopted to squeeze more money out of this investment. The stock says what it says, and who holds it doesn't make any difference to us. So, you know, got to take your lumps, essentially, Harvard. I can say that because, you know, I'm a Yale guy.
So, thank you very much.
Yeah, sure.
I did notice in the research that Blaine had done leading up to today and the article that he's working on, that one statistic, and by all means you have to be very cautious about any of these statistics, but over a fairly significant time period, the margin by which the hedge funds were beating the Standard & Poor's was like 8.9% to 8.5% or some, I mean, it was incredibly small amount. Now, it can be that's one snapshot and maybe that has nothing to do with it, but it is sort of in line with it doesn't look like the hedge funds were getting huge returns, you know, in recent years, certainly not in recent years compared to what originally, when they did start out originally in those early days, the returns were extremely impressive. Next, we're going to go to Professor Troy Paredes. I think I mistakenly indicated he was associated with the SEC. He is not. He's speaking to us about the topic of SEC regulation of hedge funds. Professor Paredes joined the faculty at Washington University School of Law in 2001 after practicing for a number of years. He's written numerous articles and made several presentations on a wide range of topics about corporate governance and securities regulation. He's also a co-author, beginning with the 4th edition of the leading multi-volume securities regulation treatise with Lewis Loss and Joel Seligman. His research interests include many things, but those also include hedge funds and executive compensation. He presently teaches corporations, securities regulations, and a seminar on the theory of the firm and corporate finance. So please welcome Troy Paredes.
Is there any way to move the computer just so Thanks, and I want to give a special thanks to all of those who helped organize this. This is a great symposium. Enjoyed the morning and certainly looking forward to the afternoon as well. So thanks to all of those who helped put this on and who thought to invite me. I very much appreciate the warm hospitality and the consideration. Hedge funds and securities regulation and the SEC is what I'll be chatting about today. Needless to say, and hence the reason for the conference, is that hedge funds are a very, very hot topic. And there's much to be said about the pros and cons of hedge funds and the regulation of hedge funds and the merits and demerits, in particular, of what the SEC has suggested doing over the years. I want to set to one side in some respects the, excuse me, I'll choke up here talking about hedge funds, the consideration of the substantive merits of whether or not we should regulate hedge funds. We can certainly come back to that and really want to address a broader inquiry, and that is to say, what can we learn about hedge fund regulation specifically and about securities regulation and, quite frankly, financial market regulation more generally still, given the Securities and Exchange Commission's recent efforts to regulate in this space, something that the Commission has refrained from doing for years, including in the aftermath of the long-term capital management debacle back in 1998. So that's the broad inquiry motivating the talk. We all basically understand, though I think the Vice Chancellor is exactly right, that there is no crisp definition and no crisp dividing line among a variety of different types of funds, be they hedge funds, private equity, or even venture capital funds. These are blurring, increasingly so. That said, we have a basic understanding, at least at the 30,000-foot level, as to what a hedge fund is. And at least for myself, one way to think about hedge funds is by the nature of the investments. And here I really think about there being two parts, and that is to say, hedge funds are looking primarily to exploit perceived inefficiencies. Traditionally, they would try to exploit mispriced assets, so there's some difference in historical pricing between two assets. They identify that the spread's too big, the spread's too narrow. You put on a trade, you expect to get a pricing that reflects historical trends, et cetera, long-short strategies, and all the rest. What we also see now, though, is another type of inefficiency that's being exploited, and that are perceived shortcomings when it comes to corporate governance. So now you see hedge funds, Richard Breeden and others, who are looking at perceived improvements in corporate governance, saying if we can affect a particular change when it comes to the governance of the enterprise, that presumably will reflect itself in some change in corporate strategy, or if nothing else, simply a reputational bump in the trading value of the company, we can turn a profit. But all that boils down to some sense that there are inefficiencies of one form or another that can be exploited to the benefit of the fund. More interestingly, for me, is another way in which we can think about categorizing or characterizing hedge funds, and that is by the degree to which they are not subject to regulation, in particular not subject to securities regulation. And here, suffice it simply to say, without getting into all of the details, that hedge funds are structured in a way that enables them to avoid the principal provisions of the Securities Act of 1933, the Securities Exchange Act of 1934, the Investment Advisors Act of 1940, and the Investment Company Act of 1940. Well, when you say all of that, I think one of the things we saw in recent years, when you say all of that, you realize there's a whole heck of a lot that hedge funds don't have to worry about or comply with. It's not just a particular part of the federal securities law. It is the principal driving provisions of these four cornerstone statutes. You take that, coupled with the fact that the hedge fund industry, as was already pointed out, has exploded in recent years, you end up with, I think, a circumstance where regulators and others sat back and said, maybe we ought to take another look. Maybe this is something that we ought to be paying some additional attention to. So what do we get, at least when it comes to the Commission, the SEC? What we get is an effort to change the regulatory landscape in 2004, when in a very divisive and controversial rulemaking that ended in a 3-2 vote, the SEC changed its historic direction and decided to regulate hedge funds. What the SEC attempted to do was to, in effect, subject managers of hedge funds to the registration requirements of the Investment Advisors Act. The hedge funds themselves were still not subject to the 33 Act, the 34 Act, and certainly were not lumped in with mutual funds, but we're going to have to be subject to the investment advisor registration requirements under the Federal Investment Advisors Act, not a trivial thing by any stretch. How long did that regime stay in place? About 6 months. What did we get? Well, we got the Goldstein decision in 2006, where the D.C. Circuit Court of Appeals ruled that this rulemaking was basically arbitrary and threw it out. You then go back to the starting point, if you will, for the Commission, which is to say, all right, what do we do? Well, the Commission chose not to appeal Goldstein, but did decide to do something else eventually. And this sets up my first observation on, if you will, the how and why of securities regulation, and that is to say the prospect of what I'll refer to generally as investor-side regulation. After Goldstein, as I said, the SEC did not appeal did not go back and try to even tweak its rulemaking in order to find a way to fit within the requirements and subsequently subject hedge fund managers to the Federal Investment Advisors Act. Instead, what the SEC did was adopt the following approach, and that is to say, to go back and revisit who can effectively and who cannot invest in hedge funds. So let me just take a quick step back by way of brief background. Hedge funds limit their investors to so-called accredited investors because that allows them to take advantage of certain safe harbors under the 1933 Securities Act, which means they don't have to register the offering of their securities, the membership interest if it were to be an LLC, or the LP interest if it's a limited partnership. They don't have to satisfy the Section 5 registration requirements under the 1933 Securities Act if they only have accredited investors. Who are accredited investors? Well, in effect, institutional investors or, quote, wealthy individuals. If you make $200,000 a year by yourself or $300,000 with your spouse, or you have a net worth of $1 million, you qualify as an individual, as a natural person, as an accredited investor. What's the logic here, the theory here? Well, the theory here is that if you are a so-called accredited investor, you're sufficiently able to fend for yourself, protect your own interests, that you don't need the protection of the SEC through the 1933 Securities Act registration requirements, hence the safe harbor, and no need to register the offering by the fund, or anybody else for that matter, making a private offering under so-called Reg D of the 33 Act. After Goldstein, what did the SEC do in a way that was peculiar to hedge funds? The SEC proposed, though still has not adopted, a rule change that would require an individual to have $2.5 million worth of investments to qualify as an accredited natural person allowed to invest in hedge funds. That is to say, for purposes of hedge fund investing, the SEC proposed considerably increasing the financial threshold that one would have to pass. What's the significance of this? Well, there's a lot, but two particular points that I want to highlight. First is that the SEC's decision to go back and revisit who is and who is not an accredited investor and to come up with this new standard of accredited natural person highlights a regulatory lever that the Commission can pull. Commission can pull in the context of hedge funds, but perhaps more generally in its regulatory efforts. When considering what to do about the hedge fund industry, the SEC could do a number of things. One, it could do nothing. Two, it could, and did not propose doing this, substantively regulate hedge funds along the lines of mutual funds. Three, it could, and proposed in 2004, regulate hedge fund managers. Or four, the SEC could, in effect, regulate hedge fund investors. By redefining who qualifies as an accredited investor, it's this fourth option that the SEC, in effect, went forward with, which is to say, to regulate hedge fund investors by redetermining who can and who cannot invest. If you agree that the SEC's primary mission is investor protection, though capital formation is certainly critical as well, but to the extent one's thinking about the SEC's mission of investor protection, one way for the SEC to protect investors from what they see as the risk of hedge fund investing is to simply say, you can't invest. The other highlight from the SEC's effort at redefining who is and who is not an accredited investor is not only highlighting the lever of investor-side regulation, but the SEC's proposal also highlights that retail investors don't have the same opportunities as sophisticated investors, as institutional investors. When the SEC in 2004 proposed subjecting hedge fund managers to the registration requirements of the Federal Investment Advisors Act, a lot of folks said, why not just go and increase the financial thresholds under Reg D for who is and who is not an accredited investor. Those financial thresholds of $1 million and $200,000, $300,000 that I referred to earlier have been in place at those limits for over 20 years. And there's a little something called inflation that would make one think that perhaps those numbers should go up. Many people thought that was the most straightforward move. That's not what the Commission chose to do. So when the Commission, in effect, chose to do that in the context of hedge funds in its more recent proposal, I think there was widespread belief that this was going to sail through easily and was not a controversial move. Wrong. It actually turned out to be a controversial move. The SEC received a number of comments, and it was picked up in the Journal and other publications, a number of comments from retail investors, from individuals who were going to be or who were worried about being excluded from participating, criticizing the SEC's proposal, in effect saying, while we perhaps appreciate what the Commission does to protect our interests, thank you very much, but no thank you this go-around. We are able to decide for ourselves whether or not we want to allocate our capital to these particular investment opportunities. In some sense, investors were saying we're willing to forego that degree of investor protection because what we'd rather have is investor participation. Well, this introduces some fundamental concerns, I think, on a going forward basis for securities markets and securities regulators. If investors believe, and there seems to be an increasing sense along these lines, that there are two markets, that is to say one market for the insiders, right, by which I mean institutional investors, wealthy individuals, the sophisticated, and another market for the retail investors, that raises concerns about individual, at least the retail's faith in the integrity of the system, faith in the integrity of the marketplace, faith in the integrity of the Securities and Exchange Commission. It feeds into concerns that go back, quite frankly, most recently to the Enron WorldCom wave of scandals, that the financial system is rigged. And here, since that it's rigged in a way that says the good stuff is for everybody else, the not-so-great stuff is for you. Right? That produces a fundamental challenge, and it's interesting that, quite frankly, here at Penn, recently the GC at the SEC, Brian Cartwright, gave a speech where he talked about de-retailization. And there were lots of things he mentioned in his speech, which is public, lots of things he mentioned in his speech, but one is this sense that there are two markets. What does that mean for how the Commission goes about approaching securities regulation on a going forward basis? Why is this important, this particular point important? Well, because investor confidence is an important underpinning of the operation of our financial markets and system. Now, to go back and constantly say investor confidence is a basis for regulating or for doing something is itself problematic that we can get into, but it's important to recognize that one has to have one's eye on the investor confidence ball in thinking about how best to go about regulating our financial markets. Let me make a second observation and then leave some time for Q&A. Second observation stemming from the SEC's effort to redefine who is and who is not an accredited investor, this accredited natural person standard for hedge funds, is, or concerns, I should say, the boundary between government intervention and market discipline. As I suggested, a primary goal of the SEC is to protect investors from fraud and other forms of insider opportunism. And without a doubt, there are worries, as I think were already alluded to, that hedge funds are secretive and shadowy, and certainly that hedge fund investors, while they have information, and much better information than many give them credit, certainly don't have perfect information. That all being said, the SEC, again, until 2004, deferred to market discipline as the preferred way, if you will, to regulate without the regulators coming in, leave it to investors to regulate hedge funds and managers and all the rest, in effect, private ordering. The government intervention market discipline boundary, though, is in some respects determined by the definition of accredited investor, because it draws the line between when there's the need for the SEC to step in through the 33 Act and when there is not. And so what we have with the proposed change definition of accredited natural person is we have some redrawing of the government intervention market discipline boundary for hedge fund investing as, in effect, fewer individuals are deemed sufficiently able to fend for themselves, because you have to now satisfy a $2.5 million investments standard in order to be able to participate in a Reg D offering as an investor that escapes the regulatory burdens of the 33 Act. So one option here is for the SEC to continue to try to redraw and figure out at what point do we think actually investors need our protection. We'll accommodate that line through our definition of the accredited investor standard under Reg D. But I actually want to suggest that even in circumstances when the SEC is deferring, as it presently has and as it may on a going forward basis, to market discipline as compared to more intrusive government intervention, that's not to say that there's not a role for the SEC to be playing when it comes to market discipline itself. In that sense, it's not an either or. What I mean by that is the following. I think there is room for the SEC to play a role in leveraging market discipline. Here, let me just give one example, and that is to say best practices. There's nothing to stop the Securities and Exchange Commission from articulating what it sees as best practices for hedge funds, hedge fund managers, hedge fund investors. The SEC could take advantage of its long-standing status as a highly respected expert institution through its releases, through guidance, through speeches, through articles, through op-eds, and all the rest, articulate its view of best practices. Now, are best practices perfect? No. There are lots of concerns about a best practices approach, which I'll just table and maybe we can chat about later. But the one thing best practices do is they do provide a yardstick. They do provide concrete guidance that then those participating in the marketplace, market actors, can then use to assess the behavior of others. And that, I think, has some merit. And when I think about that, it's hard for me not to think, quite frankly, about what the Delaware judiciary does, which is to say kind of an aspirational approach in considerable part, corporate law sermons at Rock and otherwise. And so there's a little bit of that flavor marbled into this suggestion. When it comes to best practices in particular, it's worth noting that the President's Working Group on Financial Markets has suggested just this very type of an approach, having appointed a couple of committees this past fall or late summer to come up with a series of best practices when it comes to the hedge fund industry. Even when, and I think there are circumstances, even when a regulator, be it the SEC or some other regulatory body, might decide we would like to sit tight, maybe best practices are something we would like to do, but we, in fact, need to step up and do something. Politics can matter in a rulemaking context for any administrative agency. One option that goes a little bit further than best practices is default rules. So you could have imagined a circumstance back in 2004 when the Commission was deciding what to do, and instead of mandating investment advisor registration for hedge funds, the SEC could have done something like the following. Comply or explain, right? Which is to say, you have to register if you are a hedge fund manager as an investment advisor under the Federal Investment Advisors Act. Unless you choose not to, you have an opt-out ability. But if you opt out, you have to explain to your investors why you're choosing to opt out. Right? Defaults are a classic alternative to mandates. They provide some safety valve with explanation. There's some kind of, they're more than best practices, but they're not as far on the extreme or the continuum as mandates, and have a whole host of virtues, I think, again, rooted in the fact that there's a safety valve quality to an opt-out. Are opt-outs sticky? Yes, opt-outs are sticky for lots of reasons, and so therefore there may not be quite the difference between an opt-out default versus a mandate as what we might think in theory because of the practicality of it all. But it's another aspect, another way of considering an approach if there's the desire and if there's the perceived need to do something that's short of requiring all hedge fund managers to behave in a certain way. I mean, one thing we all know for sure is that one size doesn't fit all. So anyway, a few observations on securities regulation, the SEC, and hedge funds, and in the remaining 5 minutes or so, I'd be happy to answer any questions.
Hi. In light of the fact that with the recent proposal, I think the 2003 staff report from the Commission says that if the proposal were adopted, the field of investors that would be affected would shrink from 8.47% of the population to 1.3%. And then you have to, if that field of investors or prospective investors is further winnowed down by people that hedge funds will actually accept, you know, the opening spots, depending on what pools of investments are available. What kind of incentive does, I mean, so they adopt the regulation, it moves forward. How does this even, or they don't and they encourage these best practices, what incentive is there for hedge funds to even adopt any of these, you know, the best practices or an opt-out type? I mean, obviously you can kind of stave off the adoption of this type of a proposal, or maybe future ones with an opt-out program, but I mean, what's their incentive really?
Yeah, so let me just be clear on one thing, right? So, and we can get into this. The point here is less to say I think the Commission should, given where they presently are, do anything, right? And including an opt-out or best practice, right? So it's really an effort to lay out what the range of approaches available to the Commission are, right? The range of approaches that they can take on the table are. So that's just by way of saying I don't want to leave the impression I was advocating one over the other necessarily. What's interesting in particular about the investment advisor registration requirement is, and I've written on this, and I was critical, quite frankly, of that approach because of the fact that you do have limits on who can invest. I mean, to the essence of your question, limits that aren't just about whether they're accredited investors or not. But the fact of the matter is you also have minimums. So even if you would qualify as an accredited, do you have the resources, in fact, to offer up the minimum? A lot of funds are closed and all the rest. So it's not the case that you see a flood of kind of just barely accreditors coming in. That said, for smaller startup hedge funds, you do hear some concerns that this actually does crimp their ability to raise capital. You also have, I think, a conflation of concerns in the whole discussion, which is when you get to the so-called funds of funds, and you get to the ways in which retail investors have exposure to hedge funds. But a fund of funds is a very different creature. If you're talking about a fund of funds, and if it in fact truly is engaging in general solicitations, if it in fact truly is allowing retail investors to participate, it's triggering a whole host of other regulatory requirements. So at that point, the notion that hedge funds are lightly regulated, while you may have hedge funds in the traditional sense being lightly regulated, funds of funds have now, in effect, structured themselves in a way because of the effort to tap into a wider body of capital so that they're subject to a whole panoply of federal securities law requirements. So a lot of that all gets marbled in. When you go to the investment advisor registration requirement, once you start, if you're willing to start with the notion that accredited investors are sufficiently able to fend for themselves, that would suggest they don't need to get the benefit of the protection that's invited, that is triggered as a result of investment advisor registration, right? They can price perfectly or imperfectly, right? They're in a position to price the value of the back office operations, the extent to which there are audited financials, the extent to which there are disclosures, the compensation system, and all the rest, and decide for themselves, do I want to invest or do I not want to invest? And they're presumed to have that degree of sophistication. So why are we adding a requirement, which is investment advisor registration, given who's investing in hedge funds? Now, if the argument is, well, we're not particularly convinced that accredited investors are sufficiently sophisticated to be able to fend for themselves, and so we no longer feel comfortable deferring to market discipline, and so therefore there's a need for greater government oversight, hence the 04 rulemaking that was then overturned in Goldstein, then it strikes me that the more narrowly targeted approach is not to create a regime that triggers the Investment Advisors Act, but to rather go back and try to better calibrate who is and who is not an accredited investor, so we have more confidence that those who are investing are in fact able to fend for themselves. There's one interesting aspect which I didn't mention but which I'll flag about what the SEC did on the accredited natural person proposal. The SEC has historically rejected any sort of merit review, substantive review, right? It's a disclosure philosophy, it's a disclosure-based regulatory regime with the exception of the Investment Company Act and mutual funds for the most part. What you see when you read the proposal for accredited natural person is you see a lot of discussion, or some discussion, to be fair, about the riskiness and the complex nature of investing in hedge funds. And so you end up having a circumstance where the Commission suggests these are sufficiently risky that we need to, in this particular instance, for these particular investments, elevate who is and who is not, in effect, accredited. I must say, it makes me a little antsy for the Commission to start drawing those distinctions, saying this is more risky, this is less risky, and to have then kind of a multiplicity of accredited investor definitions based on the Commission's assessment of the riskiness of these different kinds of funds. To be sure, hedge funds are risky, although I would suggest investing in a lot of public companies is risky, and a lot of public companies are themselves very, very, very complicated. And so I would caution trying to draw those distinctions. And I think one thing we've seen out of this rulemaking as well is when you actually start slicing and dicing through the federal securities laws, you realize there are now lots of different categories of investors. One issue that I think is appropriately is worth considering is whether there should be some sort of harmonization. We have qualified purchasers, we have sophistication requirements, we have qualified clients, we have accredited natural persons, we have accredited investors, we may have large accredited investors. Maybe it's time to sit back and look at all of these and say, is there some way to harmonize and rationalize these different standards? Thanks.